Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about patent unreasonableness. Cases that should have gone to the Supreme Court of Canada, but didn't. In late 2019, the Supreme Court of Canada released a decision in a case called Vavilov that effectively rewrote the standard of review in Canada, except it really didn't. People who deal with administrative law in Canada were waiting with bated breath to see what the Supreme Court of Canada would do, and effectively all they did was adopt some BC case law that talked about manifest flaws in reasoning, but otherwise left the reasonableness standard largely unchanged from what it was before. The court also provided some guidance as to how to determine when the reasonableness standard applies versus when a correctness standard of review applies. Correctness is a less deferential standard than reasonableness, which means that it's more simple, in some circumstances, to attack the decision maker's decision as a result of the lower standard of review. In Canadian law, numerous statutes throughout the country apply a third standard of review that wasn't dealt with in Vavilov, patent unreasonableness. And this was the standard of review that applied by legislation to a case involving the Red Chris Mine Company. The Red Chris Mine Company essentially argued that the remainder of legislation that dealt with the patent unreasonableness standard needed to be assessed in light of Vavilov, and a question needed to be answered about whether these higher deferential standards of review that require more deference to the decision maker than even under the reasonableness standard continued to survive in legislation after the Supreme Court of Canada's decision in Vavilov. Essentially asking the question of whether or not governments can enact a different standard of review with more deference to a decision maker in light of the Supreme Court of Canada's clear guidance in Vavilov about whether or not the reasonableness standard applies or the correctness standard applies, and that there are only two standards of review in Canadian law. This case obviously raises very important issues because this has the potential to impact decision-making all across the country. Even in British Columbia, we see the Administrative Tribunals Act that can essentially defer the determination of standard of review to legislation, where if it's enacted pursuant to the Administrative Tribunals Act, the standard of review is patent unreasonableness, which makes it much more difficult for people in dealing with these tribunals in British Columbia and in other provinces in this country to deal with the decision-making that affects them directly. And the Supreme Court of Canada had an opportunity here to answer what might be the only question that's left unanswered by Vavilov, which is what happens to patent unreasonableness? And is it really open to legislatures to continue to create new standards of review when the Supreme Court of Canada is trying to say that there are only two? This case had an important opportunity, and the Supreme Court of Canada missed it, which means there remains to be confusion in Canadian law about whether or not the patent unreasonableness standard survives and how it is to be applied now that there is this further guidance from the Supreme Court of Canada. Hopefully another case addresses this issue soon, but in the meantime, we all get to continue to be confused by administrative law. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.